Title 2 is all about the persons criminally liable for felonies. Article 16. Who are criminally liable? The following are criminally liable for grave and less grave felonies. 1. Principals. 2. Accomplices. 3. Accessories. The following are criminally liable for light felonies. 1. Principals. 2. Accomplices. Article 17. Principals. The following are considered principals. 1. Those who take a direct part in the execution of the act. 2. Those who directly force or induce others to commit it. 3. Those who cooperate in the commission of the offense by another act, without which it would not have been accomplished. Article 18. Accomplices. Accomplices are the persons who, not being included in Article 17, cooperate in the execution of the offense by previous or simultaneous acts. Article 19. Accessories. Accessories are those who, having knowledge of the commission of the crime and without having participated therein, either as principals or accomplices, take part subsequent to its commission in any of the following manners. 1. By profiting themselves or assisting the offender to profit by the effects of the crime. 2. By concealing or destroying the body of the crime or the effects or instruments thereof in order to prevent its discovery. 3. By harboring, concealing, or assisting in the escape of the principal of the crime, provided the accessory acts with abuse of his public functions, or whenever the author of the crime is guilty of treason, parricide, murder, or an attempt to take the life of the chief executive, or is known to be habitually guilty of some other crime. Article 20. Accessories who are exempt from criminal liability. The penalties prescribed for accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degrees, with the single exception of accessories falling within the provisions of paragraph 1 of the next preceding article. Title 3 is all about penalties. Chapter 1, Penalties in General. Article 21. Penalties that may be imposed. No felony shall be punishable by any penalty not prescribed by law prior to its commission. Article 22. Retroactive effect of penal laws. Penal laws shall have a retroactive effect insofar as they favor the person guilty of a felony who is not a habitual criminal, as this term is defined in Rule 5 of Article 62 of this Code. Although at the time of the publication of such laws, a final sentence has been pronounced and the convict is serving the same. Article 23. Effect of pardon by the offended party. A pardon by the offended party does not extinguish criminal action except as provided in Article 344 of this Code, but civil liabilities with regard to the interest of the injured party is extinguished by his express waiver. Article 24. Measures of prevention or safety which are not considered penalties. The following shall not be considered as penalties. 1. The arrest and temporary detention of accused persons, as well as their detention by reason of insanity or imbecility or illness requiring their confinement in a hospital. 2. The commitment of a minor to any of the institutions mentioned in Article 80 and for the purposes specified therein. 3. Suspension from the employment or public office during the trial in order to institute proceedings. 4th, fines and other corrective measures which in the exercise of their administrative or disciplinary powers superior officials may impose upon their subordinates. 5. Deprivation of rights and the reparations which the civil law may establish in penal form. Chapter 2 is all about the classification of penalties. Article 25. Penalties which may be imposed. The penalties which may be imposed according to this code and their different classes are those included in the following. Scale principal penalties. Capital punishment is death. Afflictive penalties are reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and prisión mayor. Correctional penalties: prisión correccional, arresto mayor, suspension, dischero. Light penalties: arresto menor, public censure. Penalties common to the three preceding classes: fine and bond to keep the peace. Accessory penalties: perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, suspension from public office, the right to vote and be voted for, the profession or calling. Next is civil interdiction. Next is indemnification. Then forfeiture or confiscation of instruments and proceeds of the offense. And lastly, the payment of costs. Article 26, fine. When afflictive, correctional, or light penalty. A fine, whether imposed as a single or as an alternative penalty, shall be considered an afflictive penalty if it exceeds 6,000 pesos. A correctional penalty if it does not exceed 6,000 pesos but is not less than 200 pesos, and a light penalty if it be less than 200 pesos. Chapter 3, the duration and effect of penalties. Section 1, duration of penalties. Article 27, reclusion perpetua. The penalty of reclusion perpetua shall be from 20 years and 1 day to 40 years. Reclusion temporal. The penalty of reclusion temporal shall be from 12 years and 1 day to 20 years. Prisión mayor and temporary disqualification. The duration of the penalties of prisión mayor and temporary disqualification shall be from 6 years and 1 day to 12 years, except when the penalty of disqualification is imposed as an accessory penalty, in which case its duration shall be that of the principal penalty. Prisión correccional, suspension, and dischero. The duration of the penalties of prisión correccional, suspension, and dischero shall be from 6 months and 1 day to 6 years, except when suspension is imposed as an accessory penalty, in which case its duration shall be that of the principal penalty. Arresto mayor. The duration of the penalty of arresto mayor shall be from 1 month and 1 day to 6 months. Arresto menor. The duration of the penalty of arresto menor shall be from 1 day to 30 days. Bond to keep the peace. The bond to keep the peace shall be required to cover such period of time as the court may determine, as amended by RA number 7659. Article 28, computation of penalties. If the offender shall be in prison, the term of the duration of the temporary penalties shall be computed from the day on which the judgment of conviction shall have become final. If the offender be not in prison, the term of the duration of the penalty consisting of deprivation of liberty shall be computed from the day that the offender is placed at the disposal of the judicial authorities for the enforcement of the penalty. The duration of the other penalties shall be computed only from the day on which the defendant commences to serve his sentence. Article 29, period of preventive imprisonment deducted from term of imprisonment. Offenders or accused who have undergone preventive imprisonment shall be credited in the service of their sentence consisting of deprivation of liberty with the full time during which they have undergone preventive imprisonment if the detention prisoner agrees voluntarily in writing after being informed of the effects thereof and with the assistance of counsel to abide by the same disciplinary rules imposed upon convicted prisoners, except in the following cases. 1. When they are recidivists or have been convicted previously twice or more times of any crime, and 2, when upon being summoned for the execution of their sentence, they have failed to surrender voluntarily. If the detention prisoner does not agree to abide by the same disciplinary rules imposed upon convicted prisoners, he shall do so in writing with the assistance of a counsel, and shall be credited in the service of his sentence with 4/5 of the time during which he has undergone preventive imprisonment. Credit for preventive imprisonment for the penalty of reclusion perpetua shall be deducted from 30 years. Whenever an accused has undergone preventive imprisonment for a period equal to the possible maximum imprisonment of the offense charged to which he may be sentenced, and his case is not yet terminated, he shall be released immediately without prejudice to the continuation of the trial thereof or the proceeding on appeal, if the same is under review. Computation of preventive imprisonment for purposes of immediate release under this paragraph shall be the actual period of detention with good conduct time allowance, provided, however, that if the accused is absent without justifiable cause at any stage of the trial, the court may motu proprio or order the rearrest of the accused, provided finally that recidivists, habitual delinquents, escapees, and persons charged with heinous crimes are excluded from the coverage of this act. In case the maximum penalty to which the accused may be sentenced is dischero, he shall be released after 30 days of preventive imprisonment. Section 2 is all about the effects of the penalties according to their respective nature. Article 30, Effects of the penalties of perpetual or temporary absolute disqualification. The penalties of perpetual or temporary absolute disqualification for public office shall produce the following effects. 1. The deprivation of the public offices and employments which the offender may have held, even if conferred by popular election. 2. The deprivation of the right to vote in any election for any popular elective office or to be elected to such office. 3. The disqualification for the offices or public employments and for the exercise of any of the rights mentioned. In case of temporary disqualification, such disqualification as is comprised in paragraphs 2 and 3 of this article shall last during the term of the sentence. 4th, the loss of all rights to retirement pay or other pension for any office formerly held. Article 31, Effects of the penalties of perpetual or temporary special disqualification. The penalties of perpetual or temporary special disqualification for public office, profession, or calling shall produce the following effects. 1. The deprivation of the office, employment, profession, or calling affected. 2. The disqualification for holding similar offices or employments either perpetually or during the term of the sentence according to the extent of such disqualification. Article 32 is all about the effects of the penalties of perpetual or temporary special disqualification for the exercise of the right of suffrage. The perpetual or temporary special disqualification for the exercise of the right of suffrage shall deprive the offender perpetually or during the term of the sentence, according to the nature of said penalty, of the right to vote in any popular election for any public office or to be elected to such office. Moreover, the offender shall not be permitted to hold any public office during the period of his disqualification. Article 33, Effects of the penalties of suspension from any public office, profession, or calling, or the right of suffrage. The suspension from public office, profession, or calling, and the exercise of the right of suffrage shall disqualify the offender from holding such office or exercising such profession or calling or right of suffrage during the term of sentence. The person suspended from holding public office shall not hold another having similar functions during the period of his suspension. Article 34, Civil Interdiction. Civil interdiction shall deprive the offender during the time of his sentence of the rights of parental authority or guardianship, either as to the person or property of any ward of marital authority, of the right to manage his property, and of the right to dispose of such property by any act or any conveyance inter vivos. Article 35. Effects of bond to keep the peace. It shall be the duty of any person sentenced to give bond to keep the peace to present two sufficient sureties who shall undertake that such person will not commit the offense sought to be prevented, and that in case such offense be committed, they will pay the amount determined by the court in its judgment, or otherwise to deposit such amount in the office of the clerk of the court to guarantee said undertaking. The court shall determine according to its discretion the period of duration of the bond. Should the person sentenced to fail to give the bond as required, he shall be detained for a period which shall in no case exceed 6 months, if he shall have been prosecuted for a grave or less grave felony, and shall not exceed 30 days if for a light felony. Article 36. Pardon, its effects. A pardon shall not work the restoration of the right to hold public office or the right of suffrage unless such rights be expressly restored by the terms of the pardon. A pardon shall in no case exempt the culprit from the payment of the civil indemnity imposed upon him by the sentence. Article 37. Cost. What are included? Costs shall include fees and indemnities in the course of the judicial proceedings, whether they be fixed or unalterable amounts previously determined by law or regulations in force, or amounts not subject to schedule. Article 38. Pecuniary liabilities. Order of payment. In case the property of the offender should not be sufficient for the payment of all his pecuniary liabilities, the same shall be met in the following order. First is the reparation of the damage caused. Second is the indemnification of the consequential damages. Third is the fine. Fourth and last is the cost of the proceedings. Article 39 is all about the subsidiary penalty. If the convict has no property with which to meet the fine mentioned in paragraph 3 of the next preceding article, he shall be subject to a subsidiary personal liability at the rate of 1 day for each amount equivalent to the highest minimum wage rate prevailing in the Philippines at the time of the rendition of judgment of conviction by the trial court, subject to the following rules. 1. If the principal penalty imposed be prison correctional or arresto and fine, he shall remain under confinement until his fine referred in the preceding paragraph is satisfied, but his subsidiary imprisonment shall not exceed 1/3 of the term of the sentence, and in no case shall it continue for more than 1 year, and no fraction or part of a day shall be counted against the prisoner. Second, when the principal penalty imposed be only a fine, the subsidiary imprisonment shall not exceed 6 months if the culprit shall have been prosecuted for a grave or less grave felony, and shall not exceed 15 days if for a light felony. Third, when the principal penalty imposed is higher than prison correctional, no subsidiary imprisonment shall be imposed upon the culprit. Fourth, if the principal penalty imposed is not to be executed by confinement in a penal institution, but such penalty is of fixed duration, the convict during the period of time established in the preceding rules shall continue to suffer the same deprivations as those of which the principal penalty consists. Fifth, the subsidiary personal liability which the convict may have suffered by reason of his insolvency shall not relieve him from the fine in case his financial circumstances should improve, as amended by RA number 5465, which lapsed into law on April 21, 1969, as amended by RA 10159, approved April 10, 2012. Section 3. Penalties in which other accessory penalties are inherent. Article 40. Death, its accessory penalties. The death penalty, when it is not executed by reason of commutation or pardon, shall carry with it that of perpetual absolute disqualification and that of civil interdiction during 30 years following the date of sentence, unless such accessory penalties have been expressly remitted in the pardon. Article 41. Reclusion perpetua and reclusion temporal, their accessory penalties. The penalties of reclusion perpetua and reclusion temporal shall carry with them that of civil interdiction for life or during the period of the sentence, as the case may be, and that of perpetual absolute disqualification which the offender shall suffer, even though pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. Article 42. Prisión mayor, its accessory penalties. The penalty of prison mayor shall carry with it that of temporary, absolute disqualification and that of perpetual special disqualification from the right of suffrage, which the offender shall suffer although pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. Article 43, Prison Correctional, its accessory penalties. The penalty of prison correctional shall carry with it that of suspension from public office, from the right to follow a profession or calling, and that of perpetual special disqualification from the right of suffrage, if the duration of said imprisonment shall exceed 18 months. The offender shall suffer the disqualification provided in this article, although pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. Article 44, Arresto, its accessory penalties. The penalty of arresto shall carry with it that of suspension of the right to hold office and the right of suffrage during the term of the sentence. Article 45, Confiscation and forfeiture of the proceeds or instruments of the crime. Every penalty imposed for the commission of a felony shall carry with it the forfeiture of the proceeds of the crime and the instruments or tools with which it was committed. Such proceeds and instruments or tools shall be confiscated and forfeited in favor of the government, unless they be the property of a third person not liable for the offense. But those articles which are not subject of lawful commerce shall be destroyed. Chapter 4 is all about the application of penalties. Section 1, Rules for the application of penalties to the persons criminally liable and for the graduation of the same. Article 46, Penalty to be imposed upon principals in general. The penalty prescribed by law for the commission of a felony shall be imposed upon the principals in the commission of such a felony. Whenever the law prescribes a penalty for a felony in general terms, it shall be understood as applicable to the consummated felony. Article 47. In what cases the death penalty shall not be imposed? Automatic review of death penalty cases. The death penalty shall be imposed in all cases in which it must be imposed under existing laws, except when the guilty person is below 18 years of age at the time of the commission of the crime, or is more than 70 years of age, or when, upon appeal or automatic review of the case by the Supreme Court, the required majority vote is not obtained for the imposition of the death penalty, in which cases the penalty shall be reclusion perpetua. In all cases where the death penalty is imposed by the trial court, the records shall be forwarded to the Supreme Court for automatic review and judgment by the court en banc within 20 days, but not earlier than 15 days after promulgation of judgment or the notice of denial of any motion for new trial or reconsideration. The transcript shall also be forwarded within 10 days after the filing thereof by the stenographic reporter, amended by RA number 9346. Article 48, Penalty for complex crimes. When a single act constitutes two or more grave or less grave felonies, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Article 49. Penalty to be imposed upon the principals when the crime committed is different from that intended. In cases in which the felony committed is different from that which the offender intended to commit, the following rules shall be observed. 1. If the penalty prescribed for the felony committed be higher than that corresponding to the offense which the accused intended to commit, the penalty corresponding to the latter shall be imposed in its maximum period. Number 2, if the penalty prescribed for the felony committed to be lower than that corresponding to the one which the accused intended to commit, the penalty for the former shall be imposed in its maximum period. Number 3, the rule established by the next preceding paragraph shall not be applicable if the acts committed by the guilty person shall also constitute an attempt or frustration of another crime. If the law prescribes a higher penalty for either of the latter offenses, in which case the penalty provided for the attempt or the frustrated crime shall be imposed in the maximum period. Article 50, Penalty to be imposed upon principals of a frustrated crime. The penalty next lower in degree than that prescribed by law for the consummated felony shall be imposed upon the principals in a frustrated felony. Article 51, Penalty to be imposed upon principals of attempted crime. A penalty lower by 2 degrees than that prescribed by law for the consummated felony shall be imposed upon the principals in an attempt to commit a felony. Article 52, penalty to be imposed upon accomplices in a consummated crime. The penalty next lower in degree than that prescribed by law for the consummated felony shall be imposed upon the accomplices in the commission of a consummated felony. Article 53, penalty to be imposed upon accessories to the commission of a consummated felony. The penalty lower by 2 degrees than that prescribed by law for the consummated felony shall be imposed upon the accessories to the commission of a consummated felony. Article 54, penalty to be imposed upon accomplices in a frustrated crime. The penalty next lower in degree than that prescribed by law for the frustrated felony shall be imposed upon the accomplices in the commission of a frustrated felony. Article 55, penalty to be imposed upon accessories of a frustrated crime. The penalty lower by 2 degrees than that prescribed by law for the frustrated felony shall be imposed upon the accessories to the commission of a frustrated felony. Article 56, penalty to be imposed upon accomplices in an attempted crime. The penalty next lower in degree than that prescribed by law for an attempt to commit a felony shall be imposed upon the accomplices in an attempt to commit the felony. Article 57, penalty to be imposed upon accessories of an attempted crime. The penalty lower by 2 degrees than that prescribed by law for the attempt shall be imposed upon the accessories to the attempt to commit a felony. Article 58, additional penalty to be imposed upon certain accessories. Those accessories falling within the terms of paragraph 3 of Article 19 of this Code who should act with abuse of their public functions shall suffer the additional penalty of absolute perpetual disqualification if the principal offender shall be guilty of a grave felony, and that of absolute temporary disqualification if he shall be guilty of a less grave felony. Article 59, penalty to be imposed in case of failure to commit the crime because the means employed or the aims sought are impossible. When the person intending to commit an offense has already performed the acts for the execution of the same, but nevertheless the crime was not produced by reason of the fact that the act intended was by its nature one of impossible accomplishment, or because the means employed by such person are essentially inadequate to produce the result desired by him, the court, having in mind the social danger and the degree of criminality shown by the offender, shall impose upon him the penalty of arresto mayor or a fine ranging from 200 to 500 pesos. Article 60, exceptions to the rules established in Articles 50 to 57. The provisions contained in Articles 50 to 57, inclusive of this code, shall not be applicable to a case in which the law expressly prescribes the penalty provided for a frustrated or attempted felony or to be imposed upon accomplices or accessories. Article 61, rules of graduating penalties. For the purpose of graduating the penalties, which, according to the provisions of Articles 50 to 57, inclusive of this code, are to be imposed upon persons guilty as principals of any frustrated or attempted felony or as accomplices or accessories, the following rules shall be observed. 1. When the penalty prescribed for the felony is single and indivisible, the penalty next lower in degree shall be that immediately following that indivisible penalty in the respective graduated scale prescribed in Article 71 of this Code. 2. When the penalty prescribed for the crime is composed of 2 indivisible penalties or of one or more divisible penalties to be imposed to their full extent, the penalty next lower in degree shall be that immediately following the lesser of the penalties prescribed in the respective graduated scale. 3. When the penalty prescribed for the time is composed of 1 or 2 indivisible penalties and the maximum period of another divisible penalty, the penalty next lower in degree shall be composed of the medium and minimum periods of the proper divisible penalty and the maximum period of that immediately following in said respective graduated scale. 4. When the penalty prescribed for the crime is composed of several periods corresponding to different divisible penalties, the penalty next lower in degree shall be composed of the period immediately following the minimum prescribed and of the 2 next following, which shall be taken from the penalty prescribed, if possible otherwise, from the penalty immediately following in the above mentioned respective graduated scale. Fifth, when the law prescribes a penalty for a crime in some manner not specially provided for in the four preceding rules, the courts, proceeding by analogy, shall impose the corresponding penalties upon those guilty as principals of the frustrated felony or of attempt to commit the same, and upon accomplices and accessories. Section 2 rules for the application of penalties with regard to the mitigating and aggravating circumstances and habitual delinquency. Article 62 effects of the attendance of mitigating or aggravating circumstances and of habitual delinquency. Mitigating or aggravating circumstances and habitual delinquency shall be taken into account for the purpose of diminishing or increasing the penalty in conformity with the following rules. 1. Aggravating circumstances which in themselves constitute a crime, especially punishable by law, or which are included by the law in defining a crime and prescribing the penalty, therefore, shall not be taken into account for the purpose of increasing the penalty. 1-1A. When in the commission of the crime, advantage was taken by the offender of his public position, the penalty to be imposed shall be in its maximum regardless of mitigating circumstances. The maximum penalty shall be imposed if the offense was committed by any person who belongs to an organized or syndicated crime group. An organized or syndicated crime group means a group of two or more persons collaborating, confederating, or mutually helping one another for purposes of gain in the commission of any crime, as amended by RA number 7659. Number 2, the same rule shall apply with respect to any aggravating circumstances inherent in the crime, to such a degree that it must of necessity accompany the commission thereof. Number 3, aggravating or mitigating circumstances which arise from the moral attributes of the offender or from his private relations with the offended party or from any other personal cause shall only serve to aggravate or mitigate the liability of the principals, accomplices, and accessories as to whom each circumstances are attendant. Number 4, the circumstances which consist in the material execution of the act or in the means employed to accomplish it shall serve to aggravate or mitigate the liability of those persons only who had knowledge of them at the time of the execution of the act or their cooperation therein. Number 5, habitual delinquency shall have the following effects. Letter A. Upon a third conviction, the culprit shall be sentenced to the penalty provided by law for the last crime of which he be found guilty, and to the additional penalty of prison correctional in its medium and maximum periods. B. Upon a fourth conviction, the culprit shall be sentenced to the penalty provided for the last crime of which he be found guilty, and to the additional penalty of prison major in its minimum and medium periods. And letter C. Upon a fifth or additional conviction, the culprit shall be sentenced to the penalty provided for the last crime of which he be found guilty, and to the additional penalty of prison major in its maximum period to reclusion temporal in its minimum period. Notwithstanding the provisions of this article, the total of the two penalties to be imposed upon the offender in conformity herewith shall in no case exceed 30 years. For the purpose of this article, a person shall be deemed to be habitual delinquent if within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robo, hurto, estafa, or falsificación, he is found guilty of any of said crimes a third time or oftener, as amended by RA number 7659. Article 63 rules for the application of indivisible penalties. In all cases in which the law prescribes a single indivisible penalty, it shall be applied by the courts regardless of any mitigating or aggravating circumstances that may have attended the commission of the deed. In all cases in which the law prescribes a penalty composed of two indivisible penalties, the following rules shall be observed in the application thereof. 1. When in the commission of the deed there is present only one aggravating circumstance, the greater penalty shall be applied. Number 2, when there are neither mitigating nor aggravating circumstances in the commission of the deed, the lesser penalty shall be applied. And number 3, when the commission of the act is attended by some mitigating circumstance and there is no aggravating circumstance, the lesser penalty shall be applied. And lastly, number 4, When both mitigating and aggravating circumstances attended the commission of the act, the courts shall reasonably allow them to offset one another in consideration of their number and importance, for the purpose of applying the penalty in accordance with the preceding rules according to the result of such compensation. Article 64 rules for the application of penalties, which contains 3 periods. In cases in which the penalties prescribed by law contain 3 periods, whether it be a single divisible penalty or composed of 3 different penalties, each one of which forms a period in accordance with the provisions of Article 76 and 77, the courts shall observe for the application of the penalty with the following rules, according to whether there are or are no mitigating or aggravating circumstances. Number 1, where there are neither aggravating nor mitigating circumstances, they shall impose the penalty prescribed by law in its medium period. Number 2, when only a mitigating circumstance is present in the commission of the act, they shall impose the penalty in its minimum period. Number 3, when only an aggravating circumstance is present in the commission of the act, they shall impose the penalty in its maximum period. Number 4, when both mitigating and aggravating circumstances are present, the court shall reasonably offset those of one class against the other according to their relative weight. Number 5, when there are 2 or more mitigating circumstances and no aggravating circumstances are present, the court shall impose the penalty next lower to that prescribed by law in the period that it may deem applicable according to the number and nature of such circumstances. Number 6, whatever may be the number and nature of the aggravating circumstances, the courts shall not impose a greater penalty than that prescribed by law in its maximum period. And lastly, number 7, within the limits of each period, the courts shall determine the extent of the penalty according to the number and nature of the aggravating and mitigating circumstances and the greater or lesser extent of the evil produced by the crime. Article 65 rule in cases in which the penalty is not composed of 3 periods. In cases in which the penalty prescribed by law is not composed of 3 periods, the courts shall apply the rules contained in the foregoing articles, dividing into 3 equal portions the time included in the penalty prescribed, and forming 1 period of each of the 3 portions. Article 66, imposition of fines. In imposing fines, the courts may fix any amount within the limits established by law. In fixing the amount in each case, attention shall be given not only to the mitigating and aggravating circumstances, but more particularly to the wealth or means of the culprit. Article 7, penalty to be imposed when not all the requisites of exemption of the fourth circumstance of Article 12 are present. When all the conditions required in circumstance number 4 of Article 12 of this Code to exempt from criminal liability are not present, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon the culprit if he shall have been guilty of a grave felony, and arresto mayor in its minimum and medium periods if of a less grave felony. Article 68, penalty to be imposed upon a person under 18 years of age. When the offender is a minor under 18 years of age, and his case is one coming under the provisions of the paragraph next to the last of Article 80 of this Code, the following rules shall be observed. Number 1. Upon a person under 15 but over 9 years of age who is not exempted from criminal liability by reason of the court having declared that he acted with discernment, a discretionary penalty shall be imposed, but always lower by 2 degrees at least than that prescribed by law for the crime which he committed. Number 2, upon a person over 15 and under 18 years of age, the penalty next lower than that prescribed by law shall be imposed, but always in the proper period. Article 69, penalty to be imposed when the crime committed is not wholly excusable. A penalty lower by 1 or 2 degrees than that prescribed by law shall be imposed if the deed is not wholly excusable by reason of the lack of some of the conditions required to justify the same or to exempt from criminal liability in the several cases mentioned in Articles 11 and 12, provided that the majority of such conditions be present. The courts shall impose the penalty in the period which may be deemed proper in view of the number and nature of the conditions of exemption present or lacking. Article 70, successive service of sentences. When the culprit has to serve 2 or more penalties, he shall serve them simultaneously if the nature of the penalties will so permit. Otherwise, the following rules shall be observed. In the imposition of the penalties, the order of the respective severity shall be followed, so that they may be executed successively or as nearly as may be possible, should a pardon have been granted as to the penalty or penalties first imposed, or should they have been served out. For the purpose of applying the provisions of the next preceding paragraph, the respective severity of the penalties shall be determined in accordance with the following scale. Number 1, death. Number 2, reclusion perpetua. Number 3, reclusion temporal. Number 4, prisión mayor. Number 5, prisión correccional. Number 6, arresto mayor. Number 7, arresto menor. Number 8, destierro. Number 9, perpetual absolute disqualification. Number 10, temporary absolute disqualification. Number 11, suspension from public office, the right to vote and be voted for, the right to follow a profession or calling, and number 12, public censure. Notwithstanding the provisions of the rule next preceding, the maximum duration of the convict's sentence shall not be more than threefold the length of the time corresponding to the most severe of the penalties imposed upon him. No other penalty to which he may be liable shall be inflicted after the sum total of those imposed equals the same maximum period, or equals the said maximum period. Such maximum period shall in no case exceed 40 years. In applying the provisions of this rule, the duration of perpetual penalties, or pena perpetua, shall be computed at 30 years, as amended by Com Act number 217. Article 71 is all about graduated scales. In the cases in which the law prescribes a penalty lower or higher by one or more degrees than another given penalty, the rules prescribed in Article 61 shall be observed in graduating such penalty. The lower or higher penalty shall be taken from the graduated scale in which is comprised the given penalty. The courts, in applying such lower or higher penalty, shall observe the following graduated scales. Scale number 1, death. 2, reclusion perpetua. 3, reclusion temporal. 4th, prisión mayor. 5, prisión correccional. 6, arresto mayor. 7, destierro. 8, arresto menor. 9, public censure. 10, fine. Scale number 2. Number 1, perpetual absolute disqualification. 2, temporary absolute disqualification. 3, suspension from public office, the right to vote and be voted for, and the right to follow a profession or calling. 4th, public censure. And 5, fine. Article 72. Preference in the payment of the civil liabilities. The civil liabilities of a person found guilty of 2 or more offenses shall be satisfied by following the chronological order of the dates of the final judgments rendered against him, beginning with the first in order of time. Section 3. Provisions common in the last 2 preceding sections. Article 73. Presumption in regard to the imposition of accessory penalties. Whenever the courts shall impose a penalty which by provision of law carries with it other penalties according to the provisions of Articles 40, 41, 42, 43, 44, and 45 of this code, it must be understood that the accessory penalties are also imposed upon the convict. Article 74. Penalty higher than reclusion perpetua in certain cases. In cases in which the law prescribes a penalty higher than another given penalty without specifically designating the name of the former, if such higher penalty should be that of death, the same penalty and the accessory penalties of Article 40 shall be considered as the higher penalty. Article 75. Increasing or reducing the penalty of fine by 1 or more degrees. Whenever it may be necessary to increase or reduce the penalty of fine by 1 or more degrees, it shall be increased or reduced respectively, for each degree, by 1/4 of the maximum amount prescribed by law, without, however, changing the minimum. The same rules shall be observed with regard to fines that do not consist of a fixed amount but are made proportional. Article 76. Legal period of duration of divisible penalties. The legal period of duration of divisible penalties shall be considered as divided into 3 parts, forming 3 periods: the minimum, medium, and maximum, in the manner shown in the following table. Article 77. When the penalty is a complex one composed of 3 distinct penalties. In cases in which the law prescribes a penalty composed of 3 distinct penalties, each one shall form a period. The lightest of them shall be the minimum, the next the medium, and the most severe the maximum period. Whenever the penalty prescribed does not have one of the forms specific or specially provided for in this code, the periods shall be distributed applying by analogy the prescribed rules. Chapter 5 is all about the execution and service of penalties. Section 1, General Provisions. Article 78, when and how a penalty is to be executed. No penalty shall be executed except by virtue of a final judgment. A penalty shall not be executed in any other form than that prescribed by law, nor with any other circumstances or incidents than those expressly authorized thereby. In addition to the provisions of the law, the special regulations prescribed for the government of the institutions in which the penalties are to be suffered shall be observed with regard to the character of the work to be performed, the time of its performance, and other incidents connected therewith, the relations of the convicts among themselves and other persons, the relief which they may receive, and their diet. The regulations shall make provision for the separation of the sexes in different institutions or at least into different departments, and also for the correction and reform of the convicts. Article 79, suspension of the execution and service of the penalties in case of insanity. When a convict shall become insane or an imbecile after final sentence has been pronounced, the execution of said sentence shall be suspended only with regard to the personal penalty. The provisions of the second paragraph of circumstance number 1 of Article 12 being observed in the corresponding cases. If at any time the convict shall recover his reason, his sentence shall be executed, unless the penalty shall have prescribed in accordance with the provisions of this code. The respective provisions of this section shall also be observed if the insanity or imbecility occurs while the convict is serving his sentence. Article 80 is all about suspension of sentence of minor delinquents. Whenever a minor of either sex under 16 years of age at the date of the commission of a grave or less grave felony is accused thereof, the court, after hearing the evidence in the proper proceedings, instead of pronouncing judgment of conviction, shall suspend all further proceedings and shall commit such minor to the custody or care of a public or private benevolent or charitable institution established under the law for the care, correction, or education of orphaned, homeless, defective, and delinquent children, or to the custody or care of any other responsible person in any other place, subject to visitation and supervision by the Director of Public Welfare or any of his agents or representatives, if there be any, or otherwise by the Superintendent of Public Schools or his representatives, subject to such conditions as are prescribed herein below, until such minor shall have reached his majority or much less period as the court may deem proper, as amended by RA number 47. The court, in committing said minor as provided above, shall take into consideration the religion of such minor, his parents or next of kin, in order to avoid his commitment to any private institution not under the control and supervision of the religious sect or the denomination to which they belong. The Director of Public Welfare or his duly authorized representatives or agents, the Superintendent of Public Schools or his representatives, or the person to whose custody or care the minor has been committed, shall submit to the court every 4 months and as often as required in special cases a written report on the good or bad conduct of said minor and the moral and intellectual progress made by him. The suspension of the proceedings against a minor may be extended or shortened by the court on the recommendation of the Director of Public Welfare or his authorized representatives or agents, or the Superintendent of Public Schools or his representatives, according as to whether the conduct of such minor has been good or not, and whether he has complied with the conditions imposed upon him or not. The provisions of the first paragraph of this article shall not, however, be affected by those contained herein. If the minor has been committed to the custody or care of any of the institutions mentioned in the first paragraph of this article with the approval of the Director of Public Welfare and subject to such conditions as this official, in accordance with law, may deem proper to impose, such minor may be allowed to stay elsewhere under the care of a responsible person. If the minor has behaved properly and has complied with the conditions imposed upon him during his confinement, in accordance with the provisions of this article, he shall be returned to the court in order that the same may order his final release. In case the minor fails to behave properly or to comply with the regulations of the institution to which he has been committed, or with the conditions imposed upon him when he was committed to the care of a responsible person, or in case he should be found incorrigible, or his continued stay in such institution should be inadvisable, he shall be returned to the court in order that the same may render the judgment corresponding to the crime committed by him. The expenses for the maintenance of a minor delinquent confined in the constitution to which he has been committed shall be borne totally or partially by his parents or relatives or those persons liable to support him, if they are able to do so, in the discretion of the court, provided that in case his parents or relatives or those persons liable to support him have not been ordered to pay said expenses, the municipality in which the offense was committed shall pay one-third of said expenses. The province to which the municipality belongs shall pay one-third, and the remaining one-third shall be borne by the national government. Provided, however, that whenever the Secretary of Finance certifies that a municipality is not able to pay its share in the expenses above mentioned, such share which is not paid by said municipality shall be borne by the national government. Chartered cities shall pay two-thirds of said expenses, and in a case a chartered city cannot pay said expenses, the internal revenue allotments which may be due to said city shall be withheld and applied in settlement of said indebtedness in accordance with Section 588 of the Administrative Code. Section 2 is all about the execution of principal penalties. Article 81. When and how the death penalty is to be executed. The death sentence shall be executed with preference to any other penalty and shall consist in putting the person under the sentence to death by lethal injection. The death sentence shall be executed under the authority of the Director of the Bureau of the Corrections, endeavoring so far as possible to mitigate the sufferings of the person under the sentence during the lethal injection as well as during the proceedings prior to the execution. The Director of Bureau of Corrections shall take steps to ensure that the lethal injection to be administered is sufficient to cause the instantaneous death of the convict. Pursuant to this, all personnel involved in the administration of lethal injection shall be trained prior to the performance of such task. The authorized physician of the Bureau of Corrections, after thorough examination, shall officially make a pronouncement of the convict's death and shall certify thereto in the records of the Bureau of Corrections. The death sentence shall be carried out not earlier than 1 year nor later than 18 months after the judgment has become final and executory, without prejudice to the exercise by the President of his executive clemency powers at all times. Article 82. Notification and execution of the sentence and assistance to the culprit. The court shall designate a working day for the execution, but not the hour thereof, and such designation shall not be communicated to the offender before sunrise of said day, and the execution shall not take place until after the expiration of at least 8 hours following the notification, but before sunset. During the interval between the notification and the execution, the culprit shall in so far as possible be furnished such assistance as he may request in order to be attended in his last moments by priests or ministers of the religion he professes, and to consult lawyers, as well as in order to make a will and confer with members of his family or person in charge of the management of his business, of the administration of his property, or of the care of his descendants. Article 83 is the suspension of the execution of the death sentence. The death sentence shall not be inflicted upon a woman while she is pregnant or within 1 year after delivery, nor upon any person over 70 years of age. In this last case, the death sentence shall be commuted to the penalty of reclusion perpetua with the accessory penalties provided in Article 40. In all cases where the death sentence has become final, the records of the case shall be forwarded immediately by the Supreme Court to the office of the President for possible exercise of the pardoning power. Article 84. Place of execution and persons who may witness the same. The execution shall take place in the penitentiary or bilibid in a space close to the public view, and shall be witnessed only by the priests assisting the offender, and by his lawyers, and by his relatives not exceeding 6, if he so requests, by the physician and the necessary personnel of the penal establishment, and by such persons as the Director of Prisons may authorize. Article 85. Provisions relative to the corpse of the person executed and its burial. Unless claimed by his family, the corpse of the culprit shall, upon the completion of the legal proceedings subsequent to the execution, be turned over to the Institute of Learning or Scientific Research, first applying for it for the purpose of study and investigation, provided that such institute shall take charge of the decent burial of the remains. So, otherwise, the Director of Prisons shall order the burial of the body of the culprit at government expense, granting permission to be present thereat to the members of the family of the culprit and the friends of the latter. In no case shall the burial of the body of a person sentenced to death be held with pomp. Article 86. Reclusion perpetua, reclusion temporal, prison mayor, prison correctional, and resto mayor. The penalties of reclusion perpetua, reclusion temporal, prison mayor, prison correctional, and resto mayor shall be executed and served in the places and penal establishments provided by administrative code in force or which may be provided by law in the future. Article 87, Dischero. Any person sentenced to dischero shall not be permitted to enter the place or places designated in the sentence, nor within the radius therein specified, which shall not be more than 250 and not less than 25 kilometers from the place designated. Article 88, Arresto Menor. The penalty of arresto menor shall be served in the municipal jail or in the house of the defendant himself under the surveillance of an officer of the law when the court so provides in its decision, taking into consideration the health of the offender and other reasons which may seem satisfactory to it. Title 4, Extinction of Criminal Liability, Chapter 1, Total Extinction of Criminal Liability. Article 89. How criminal liability is totally extinguished. Criminal liability is totally extinguished, number 1, by the death of the convict, as to the personal penalties, and as to the pecuniary penalties. Liability, therefore, is extinguished only when the death of the offender occurs before final judgment. Number 2, by service of the sentence. Number 3, by amnesty, which completely extinguishes the penalty in all its effects. Number 4, by absolute pardon. 5, by prescription of the crime. 6, by prescription of the penalty. 7, by the marriage of the offended woman as provided in Article 344 of this code. Article 90, Prescription of crimes. Crimes punishable by death, reclusion perpetua, or reclusion temporal shall prescribe in 20 years. Crimes punishable by other afflictive penalties shall prescribe in 15 years. Those punishable by a correctional penalty shall prescribe in 10 years, with the exception of those punishable by arresto mayor, which shall prescribe in 5 years. The crime of libel or other similar offenses shall prescribe in 1 year. The offenses of oral defamation and slander by deed shall prescribe in 6 months. Light offenses prescribe in 2 months. When the penalty fixed by law is a compound one, the highest penalty shall be made the basis of the application of the rules contained in the first, second, and third paragraphs of this article, as amended by RA number 4661. Article 91, Computation of Prescription of Offenses. The period of prescription shall commence to run from the day on which the crime is discovered by the offended party, the authorities or their agents, and shall be interrupted by the filing of the complaint or information, and shall commence to run again when such proceedings terminate without the accused being convicted or acquitted or are unjustifiably stopped for any reason not imputable to him. The term of prescription shall not run when the offender is absent from the Philippine archipelago. Article 92, When and how penalties prescribe. The penalties imposed by final sentence prescribed as follows. 1. Death and reclusion perpetua in 20 years. 2. Other afflictive penalties in 15 years. 3. Correctional penalties in 10 years, with the exception of the penalty of arresto mayor, which prescribes in 5 years. And 4. Light penalties in 1 year. Article 93. Computation of the prescription of penalties. The period of prescription of penalties shall commence to run from the date when the culprit should have evaded the service of his sentence, and it shall be interrupted if the defendant should give himself up, be captured, should go to some foreign country with which this government has no extradition treaty, or should commit another crime before the expiration of the period of prescription. Chapter 2 is all about the partial extinction of criminal liability. Article 94, Partial Extinction of Criminal Liability. Criminal liability is extinguished partially, number 1, by conditional pardon, number 2, by commutation of the sentence, and number 3, for good conduct allowances which the culprit may earn while he is undergoing preventive imprisonment or serving his sentence, as amended by RA number 10592. Article 95, Obligation incurred by a person granted conditional pardon. Any person who has been granted conditional pardon shall incur the obligation of complying strictly with the conditions imposed therein. Otherwise, his non-compliance with any of the conditions specified shall result in the revocation of the pardon, and the provisions of Article 159 shall be applied to him. Article 96, Effect of commutation of sentence. The commutation of the original sentence for another of a different length and nature shall have the legal effect of substituting the latter in the place of the former. Article 97, allowance for good conduct. The good conduct of any offender qualified for credit for preventive imprisonment pursuant to Article 29 of this code, or of any convicted prisoner in any penal institution, rehabilitation or detention center, or any other local jail shall entitle him to the following deductions from the period of his sentence. Number 1, during the first 2 years of imprisonment, he shall be allowed a deduction of 20 days for each month of good behavior during detention. 2, during the 3rd to the 5th year, inclusive of his imprisonment, he shall be allowed a reduction of 23 days for each month of good behavior during detention. 3, during the following years until the 10th year, inclusive of his imprisonment, he shall be allowed a deduction of 25 days for each month of good behavior during detention. 4th, during the 11th and successive years of his imprisonment, he shall be allowed a deduction of 30 days for each month of good behavior during detention. And lastly, number 5, at any time during the period of imprisonment, he shall be allowed another deduction of 15 days in addition to numbers 1 to 4 hereof for each month of studies, teaching, or mentoring service time rendered. An appeal by the accused shall not deprive him of entitlement to the above allowances for good conduct as amended by RA number 10592, approved May 29, 2013. Article 98, special time allowance for loyalty. A deduction of 1/5 of the period of his sentence shall be granted to any prisoner who, having evaded his preventive imprisonment or the service of his sentence under the circumstances mentioned in Article 158 of this Code, gives himself up to the authorities within 48 hours following the issuance of a proclamation announcing the passing away of the calamity or catastrophe referred to in said article. A deduction of 2/5 of the period of his sentence shall be granted in case said prisoner chose to stay in the place of his confinement, notwithstanding in the existence of a calamity or catastrophe enumerated in Article 158 of this Code. This article shall apply to any prisoner, whether undergoing preventive imprisonment or serving sentence, as amended by RA number 10592, approved May 29, 2013. Article 99, who grants time allowances. Whenever lawfully justified, the Director of the Bureau of Corrections, the Chief of the Bureau of Jail Management and Penology, and or the Warden of a provincial district, municipal, or city jail shall grant allowances for good conduct. Such allowances, once granted, shall not be revoked, as amended by RA number 10592, approved May 29, 2013. Title 5 is all about civil liability. Chapter 1, persons civilly liable for felonies. Article 100, civil liability of a person guilty of felony. Every person criminally liable for a felony is also civilly liable. Article 101, rules regarding civil liability in certain cases. The exemption from criminal liability established in subdivisions 1, 2, 3, 5, and 6 of Article 12 and in subdivision 4 of Article 11 of this Code does not include exemption from civil liability, which shall be enforced subject to the following rules. First, in cases of subdivisions 1, 2, and 3 of Article 12, the civil liability for acts committed by an imbecile or insane person and by a person under 9 years of age or over 9 but under 15 years of age who has acted without discernment shall devolve upon those having such a person under their legal authority or control, unless it appears that there was no fault or negligence on their part. Should there be no person having such insane imbecile or minor under his authority, legal guardianship, or control, or if such person be insolvent, said insane imbecile or minor shall respond with their own property, excepting property exempt from execution in accordance with the civil law. Second, in cases falling within Subdivision 4 of Article 11, the persons for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they may have received. The courts shall determine in their sound discretion the proportionate amount for which each one shall be liable. When the respective shares cannot be equitably determined, even approximately, or when the liability also attaches to the government or to the majority of the inhabitants of the town, and in all events whenever the damage has been caused with the consent of the authorities or their agents, indemnification shall be made in the manner prescribed by special laws or regulations. Third, in cases falling within subdivisions 5 and 6 of Article 12, the persons using violence or causing the fear shall be primarily liable, and secondarily, or if there be no such persons, those doing the act shall be liable, saving always to the latter that part of their property exempt from execution. Article 102, Subsidiary Civil Liability of Innkeepers, Tavern Keepers, and Proprietors of Establishments. In default of the persons criminally liable, innkeepers, tavern keepers, and other persons or corporations shall be civilly liable for crimes committed in their establishments in all cases where a violation of municipal ordinances or some general or special police regulations shall have been committed by them or their employees. Innkeepers are also subsidiarily liable for the restitution of goods taken by robbery or theft within their houses from guests lodging therein, or for the payment of the value thereof, provided that such guests shall have notified in advance the innkeeper himself or the person representing him of the deposit of such goods within the inn, and shall furthermore have followed the directions which such innkeeper or his representative may have given them with respect to the care of and vigilance over such goods. No liability shall attach in case of robbery with violence against or intimidation of persons unless committed by the innkeeper's employees. Article 103, Subsidiary Civil Liability of Other Persons. The subsidiary liability established in the next preceding article shall also apply to employers, teachers, persons, and corporations engaged in any kind of industry for felonies committed by their servants, pupils, workmen, apprentices, or employees in the discharge of their duties. Chapter 2 is all about what civil liability includes. Article 104. What is included in civil liability? The civil liability established in Articles 100, 101, 102, and 103 of this code includes number 1, restitution, number 2, reparation of the damage caused, number 3, indemnification for consequential damages. Article 105, restitution, how made. The restitution of the thing itself must be made whenever possible, with allowance for any deterioration or diminution of value as determined by the court. The thing itself shall be restored even though it be found in the possession of a third person who acquired it by lawful means, saving to the latter his action against the proper person who may be liable to him. This provision is not applicable in a case in which the thing has been acquired by the third person in the manner and under the requirements which by law bar an action for its recovery. Article 106, reparation, how made. The court shall determine the amount of damage, taking into consideration the price of the thing whenever possible, and its special sentimental value to the injured party, and the reparation shall be made accordingly. Article 107, indemnification, what is included. Indemnification of consequential damages shall include not only those caused the injured party, but also those suffered by his family or by a third person by reason of the crime. Article 108, obligation to make restoration, reparation for damages, or indemnification for consequential damages, and action to demand the same, upon whom it devolves. The obligation to make restoration or reparation for damages and indemnification for consequential damages devolves upon the heirs of the person liable. The action to demand restoration, reparation, and indemnification likewise descends to the heirs of the person injured. Article 109, share of each person civilly liable. If there are two or more persons civilly liable for a felony, the courts shall determine the amount for which each must respond. Article 110, several and subsidiary liability of principals, accomplices, and accessories of felony. Preference in payment. Notwithstanding the provisions of the next preceding article, the principals, accomplices, and accessories, each within their respective class, shall be liable severally in solidum among themselves for their quotas, and subsidiarily for those of the other persons liable. Subsidiary liability shall be enforced first against the property of the principals, next against that of the accomplices, and lastly against that of the accessories. Whenever the liability in solidum or the subsidiary liability has been enforced, the persons by whom payment has been made shall have a right of action against the others for the amount of their respective shares. Article 111, obligation to make restitution in a certain case. Any person who has participated gratuitously in the proceeds of a felony shall be bound to make restitution in an amount equivalent to the extent of such participation. Chapter 3 is all about the extinction and survival of civil liability. Article 112, extinction of civil liability. Civil liability established in Articles 100, 101, 102, and 103 of this code shall be extinguished in the same manner as other obligations in accordance with the provisions of the civil law. Article 113, obligation to satisfy civil liability, except in case of extinction of his civil liability as provided in the next preceding article, the offender shall continue to be obliged to satisfy the civil liability resulting from the crime committed by him, notwithstanding the fact that he has served his sentence consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence, or any other reasons.